Article 21. No person can be deprived of his personal liberty except according to procedure established by law. This means that a person can be deprived of his life and personal liberty provided his deprivation was brought about in accordance with the procedure prescribed by law. In AK Gopalan case, it was held that the word law means state made law. Word law means state made law. This act gives the legislature the full authority to make law and prescribe any procedure it likes. Article 22 requires those procedural requirements which must be adopted and included in any procedure enacted by legislature. If these procedural requirements are not complied with, it would be deprivation of personal liberty which is not in accordance with the procedure established by law. In case of A.K. Roy versus Union of India EIR 1982 Supreme Court 710, the Supreme Court declared that the act was valid. It was neither vague nor arbitrary. Court observed that the detention should not be given punitive treatment and it should be treated with civilized norm of human dignity. What is preventive detention? What constitutional safeguards are available to detainees against preventive detention? Article 22 provides for preventive detention laws. The object is preventive detention is to prevent a person from committing a crime and not to punish him as it done under punitive detention. Preventive detention is considered undemocratic in a democratic constitution, but this provision is necessary for new nation in order to save it from different types of danger to unity and integrity. Since it is a draconian measure, the constitution, though makes a provision for it, also incorporates certain constitutional safeguards. Clause 4 to Clause 7 of Article 22 provides the following safeguard to a person detained under preventive detention. Grounds of detention must be communicated. Article 22 Clause 5 gives the right to the detainee to be communicated the grounds of detention as soon as possible. The detaining authority making the order of detention must as soon as possible communicate to the person detained the ground of his arrest and give the detainee the earliest opportunity of making representation against the order of the detention. The ground of detention must be very clear and easily understandable by the detainee. The ground of detention must be in existence at the time of making the order. No part of it can be held back, nor can new ground be added thereto. The State of Bombay versus Atma Ram AIR 1954, Supreme Court 157. Unexplained delay in considering the representation under Section 8 of NSA by a detaining authority will make the detention order invalid. It was held in Abdul Aziz vs. Delhi Administration AIR 1981, Supreme Court 1389. In Ram Bahadur vs. State of Bihar AIR 1975, Supreme Court 245, it has been held that where the order of detention is founded on distinct and separate grounds, and any of the grounds is vague or irrelevant, the entire order must fail. Number 2. Right of representation. Article 22 imposes an obligation upon the government to afford the detainee the opportunity to make the representation under Clause 5. It makes no distinction between the order of detention for only 2 months or less, those for a long duration. The obligation applies to both kinds of orders. It does not say that the representation will be considered by the appropriate government in former class of cases and by the board in the later class of cases. It is clear from clause 4 and 5 of the Article 22 that there is a dual obligation on the appropriate government and dual rights in favor of a detainee, namely number 1 to have his representation irrespective of the length of detention considered by the appropriate government, number 2 to have once again in the light of the circumstances of the case considered by the board before it gives his opinion. If in the light of the representation the board finds that there is no sufficient cause for detention, the government has to revoke the order of detention and set at liberty the detainee. Where the detaining authority commits delay in considering the representation, the detention order will become illegal. Yes, whereas the government considers the representation to ascertain whether the order is in conformity with its power under the relevant law, the board considers with representation from the point of view of arriving at its opinion whether there is sufficient cause for detention. Obligation of the appropriate government affords the detainee opportunity to make representation. which is distinct from the government obligation to constitute a board and to communicate the representation among other materials to enable it to form its opinion. The above conclusion is strengthened by Preventive Detention Act 1950, made in conformity with Clause 4 and 5 of the Article 22. Consequently, the detainee has a constitutional right, and there is on the government a corresponding constitutional obligation to consider his representation, irrespective of whether it is made before or after his case is referred to the advisory board. Pankaj Kumar versus State of West Bengal AIR 1970 SC 97. Number 3, Advisory Board. Article 22 provides that the detainee under the Preventive Detention Law shall have the right to his representation under his detention against his detention reviewed by an advisory board. Article 22 provides that the detainee under the Preventive Detention Law shall have the right to have his representation against his detention reviewed by an advisory board. If the advisory board reports that the detention is not justified, the detainee must be released forthwith. If the advisory board reports that the detention is justified, the government may fix the period for detention. The 44th Amendment Act 1978 has amended Article 22 and reduced the maximum period for which a person may be detained without obtaining the opinion of the advisory board from 3 months to 2 months. Reduce the maximum period from 3 months to 2 months. Which reduced the maximum period? 44th Amendment Act 1978 has amended the Article 22. By the 44th Amendment Act 1978, Article 22 was amended and it reduced the maximum period of detention from 3 months to 2 months without obtaining the opinion of the advisory board. It has also changed the constitution of the board, which shall now consist of a chairman and 2 other members. The chairman must be sitting judge of an appropriate high court, and the other members shall be either sitting or retired judge of any high court. The detainee has no right of legal assistance in the proceeding before the advisory board. But if the government is given such a facility, it should be equally be provided to the detainee. The discretion of the board to permit or not to permit must be exercised in conformity with Article 14 and Article 21 of the Constitution. That is, it must not be exercised arbitrarily. Nandlal vs. State of Punjab, AIR 1981, Supreme Court 204. In ADM Jabalpur vs. SS Shukla, AIR 1976, Supreme Court 1207, the Supreme Court held that where an emergency is declared, when there is an emergency, the right to enforce fundamental right under Article 21 is suspended. No person had right to go to the court for challenging the validity of his detention. Under emergency has been proclaimed. The right to enforce the fundamental right under Article 21, right to life and personal liberty, is suspended. No person has right to go to the court for challenging the validity of his detention. The effect of decision is that court would not be empowered to examine the question of malafide on grounds of the order of detention. In Makhan Singh vs. State of Punjab, AR 1964, Supreme Court 381, it was ruled that it could examine the validity of the detention on the grounds that the order was passed with malice or there was excessive delegation of power of the provision of emergency law. It was ruled in Makhan Singh vs. State of Punjab, AR 1964, SC 381, it was ruled that it could examine the validity of the detention on the ground that the order was passed with malice or there was excessive delegation of power of the provision of emergency law were not followed. The court, however, held that the Makhan Singh's case did not apply in this case. But in 44th Amendment now provides that the Article 21 will not be suspended during any emergency. During emergency, hence detention can be challenged in the court of law. Right against exploitation. The Constitution of India prohibits traffic in human beings, and beggar and other forms of forced labor. It prohibits the traffic of human beings, forced labor, and begging. There are 2 articles which guaranteed right against exploitation. Article 23 prohibits traffic in human beings and forced labor. Article 23 prohibits what it prohibits? Traffic of human beings and forced labor. Article 24 prohibits employment of children under the age of 14 years in factories and mines or in any other hazardous employment. Article 23 embodies two declarations. First, that the traffic is human being, beggar, and other forms of forced labor are prohibited. Secondly, there any contravention of the prohibition shall be offence punishable in accordance with law. Section 370 and 372 of the IPC provides the punishment against buying and selling of persons and slaves, and section 374 punishes forced labor, while section 372 punishes the selling of a minor for prostitution or immoral purposes. Section 373 punishes buyer of a minor for such person. Article 23 confers a fundamental right against a certain form of exploitation. The provision of Indian Penal Code referred to above provides the punishment of such exploitation, and Article 23 gives to such punishment a constitutional sanction. It is usual practice that the prisoners are employed in various work, in jail, with cultivation, cooking, cleaning, etc. The Supreme Court in Dina versus Union of India, AIR 1983, Supreme Court 1155, held that labor taken from prisoners without paying a proper remuneration is forced labor and violative of Article 23 of the Constitution. The prisoners are entitled to payment of reasonable wages for the work taken from them. The court is under a duty to enforce their claim. The Article 23 strikes at forced labor in whatever form it is found, because it is violative of human dignity and against human values. Labor given by a person under economic pressure is clearly a forced labor. Labor given by a person under economic pressure is clearly a forced labor and prohibited by Article 23 of the Constitution. People's Union of Democratic Rights versus Union of India, AIR 1982, Supreme Court 1473. Article 23, however, provides that nothing in the said article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, the state shall not make any discrimination on grounds only of religion, caste, or class, or any of them. This does not mean that the state is authorized to exploit. All that it means is that the state can enforce obligation which citizens owe to it in return for the protection and efficiency rendered by the state. Thus, in a war or emergency, the state can enforce conscription, and the Article 23 cannot be used to prevent the state from doing so. The purpose for which the state can enforce compulsory service must be public purpose. Article 24 says that no child below the age of 14 years shall be employed to work in a factory or mine or engaged in any other hazardous employment. Obviously, the provision is in the interest of the health and strength of young persons, and is in keeping the view of the directive principle of state policy embodied in Article 39, Clause 1 of the Constitution. In People's Union for Democratic Rights, the Union versus Union of India, AIR 1982, Supreme Court 1473, and laborers working on Salal Hydro Project versus State of Jammu and Kashmir, AIR 1984, Supreme Court 177. Supreme Court has held that the construction of building and erection of wall, etc. is a hazardous work, and therefore under Article 24, no child below the age of 14 years can be allowed to work. The language of the article is self-explanatory, and it is clear that the prohibition of the article does not apply to employment of children in any hazardous or innocent work. The language of article is self-explanatory, and it is clear that the prohibition of article does not apply to employment of children in any hazardous or harmless or innocent work. और harmless work में prohibition नहीं है, hazardous और innocent hazardous work में है prohibition. So that's all about this video. If you find it useful, let's subscribe my YouTube channel.